Hello there and welcome back. Employment Law Show. John Scholes, Lior Samfiru. We are ready to fill your head with wonderful knowledge about employment law. We often said on this show, if you're going to learn one angle of law, even just through osmosis, divorce law, real estate law, it's all good. But the one thing where you want to have your ducks in a row is where you are 8 hours a day, probably for most of your adult life. And that's employment law. So that's what we aim to do in this show, is educate you big time about the ins and outs of employment law and severance, whether you're an employer or an employee, it all matters. And we get to it all through emails and phone calls as well. Reaching out, employmentlawyer.ca. That is the website you can go to. Help at the beginning is the email address, help@employmentlawyer.ca. And the phone number, anytime, 1-855-821-5900. We'll get to all kinds of stuff today, of course, and the Pocket Employment Lawyer in just a bit. In the meantime, you want to go there, pocketemploymentlawyer.ca. But we always start with the week that was. Pal, how are you?
Hey, John, great to be back. Great to be talking about employment law. And you're absolutely right. Employment law is so important. It affects so many people, and it affects them all the time. We all have jobs. We spend a lot of time on our jobs. And employment law is what governs our workplace rights. It's what governs what we do most of our life, with most of our time. It's important. And what people don't understand is that employment laws are actually quite good. In this province, throughout the country for that matter, there's a lot of workplace rights that help employees, that protect employees. But if you don't know what the law is, if you're not giving the law an opportunity to help you, then it can't help you. And that's what we want to do. If you have a workplace issue, a question, your boss did something or said something, maybe you lost your job, worried about losing your job, and you want to know, hey, what am I owed? What does the law say about my entitlements? Well, we talk about that on this show every week, so stay tuned. I'm sure we'll cover so many things that are important to you. And of course, if you want to talk about your issue, if you don't cover this on the show, you want to talk to me privately, no problem. We'll give you my contact information throughout the show so we can connect. You can email, you can call, happy to talk. But week there was, John, a situation came across my desk very recently. Now, this is a story that recently got some media attention, got some traction in the news. This particular gentleman worked for a company for a number of years, over 6 years. And as a holiday gift, company decided, instead of a nice bonus, you know, the old bonus check that he may use to put in a pool, instead of that, to give him the old barbecue sauce.
Griswold.
That's right. That's right. And not a Jelly of the Month subscription, but a bottle of barbecue sauce.
Wow.
And, you know, he wasn't very happy. Probably I wouldn't be either. Be that as it may, he decided to go on his Twitter account and post a little snarky comment about the fact, you know, company like that should be able to do better than a barbecue sauce. By the way, didn't even identify himself, didn't identify the company. Company, though, finds out about it. And says, wait a second, we don't like that. It's a breach of our policies. You shouldn't be talking about the company. We're letting you go for cause. We're not going to pay you any compensation. You're out of here. So the guy said something about a barbecue sauce online on his own account, was terminated. And he called me and I spoke to him. And John, let's be very clear. It's not cause.
Right.
Now, would I have recommended to him to go online and post something about what the company gave him? Probably not. But the fact that maybe he did something he wasn't supposed to do does not mean it's cause. Remember, it's so difficult to establish cause. It's reserved for the worst offenders. So what he did is not even close to being cause. And I wanted to talk about that for two reasons. Number one is to remind someone that if you post something online, your employer may find out about it. And that could have workplace consequences. So if you don't want your employer to see something you post online, don't post it online.
Right.
It's as simple as that. It's hard to hide things online. But beyond that, even if you do it, even if you post something or you do something, it does not mean the company has cause to let you go. It does not mean they have a right to let you go without compensation. It is difficult to do that. It's only in extreme situations. And for this person, I'm now engaged. I'm going to help him get his compensation. You're probably looking at around 8-9 months pay that he is owed. So a significant amount of money. The same thing happens all the time. I talk to people that are let go because they did something wrong, or the company alleges that they did something wrong. But even if they did, it does not mean that's cause. Cause is not something that the company is allowed to do unless what you did, John, is so bad that it makes it impossible to continue employing you.
Now, the company could, if they had a beef with this whole situation, they could still let him go, but they would have to pay him his full compensation, his full severance, right?
They absolutely could say, you know what, we don't like what you did, we're going to let you go, but you know what, we'll pay you what we owe you. They could do that. He may not be happy, it may not be fair, but it would be legal.
Right.
They can let him go. The problem here, what makes this a wrongful dismissal, what makes most wrongful dismissals what they are, is letting someone go without their full termination entitlements.
Employmentlawyer.ca, again, the website, that is where you can find past episodes of both this show and our long-running radio show as well. We pull phone calls from the radio show, we play them on here, and we talk about them. Phone call number 1 for this show is right now.
So my wife's a social coordinator for condominium. She went overnight from being the life of the building, literally, once the board changed, with 1 or 2 people not liking her personally, to making her life hell and trying to make her quit. I wonder if there's any recourse or anything she could do before it's too late.
Yeah.
Getting harassed.
It's being harassed, it's being mistreated, it's being bullied at work. There's a lot of different words that are used to describe this type of situation. Guess what? It's all inappropriate.
Right.
A company cannot mistreat someone, they cannot bully, they cannot harass someone, they cannot try to push someone out. The problem here is always proving what's happening. So you can expect that if you're going to pursue legal action, the person that's bullying or harassing you is not going to put up their hand and say, yeah, guess what? Yeah, I did it. My bad. They're not going to do that. So it's up to the individual. It's up to you to build up that case. So what I want to do, what would I want this person's wife to do? I want her to start documenting things. I want her to start keeping track of what was said, when was said, either have some sort of a log or journal, or even better, send emails to the person mistreating and saying, we had this discussion today where you've told me X, Y, and Z. Document things that way. If you can document that, then you can pursue that harassment. If she's being mistreated and bullied, the law says that's inappropriate. We all have the right to work in a harassment-free work environment, which means if she is being harassed, she can get out of there. We can get her out of that workplace with full compensation, with full severance. Same thing applies to you. If you're being mistreated or bullied or harassed, you shouldn't have to take that. You shouldn't have to suffer. You shouldn't have to let your health be impacted. If that's your situation, let's talk about that. One of the options, probably the best option, is to get you out of that workplace, but with severance, with compensation. In the eyes of the law, John, that is a termination. If you're being mistreated and if the company won't solve that problem, that's a termination. That's something you can do something about.
It's an interesting situation, though, because you think if she's getting bullied like this, would she have any recourse? Would there be any damages above just getting severance or something like that?
Depends. In some situations, it could be a human rights matter.
Yeah.
If she's being mistreated because maybe she is a woman and the guys mistreating her are men and they're bullying her because of that, that could be a human rights issue. If maybe she's being bullied or harassed because of her age or maybe because of a medical condition, that is, again, that's a human rights violation. So in many of these situations, we have this intersection between harassment and human rights. And if that happens, yeah, there's additional significant compensation that may be owed.
Does it matter if your emails get a response or not? It doesn't matter. They're out there, right?
Absolutely. Sending an email, you don't need a response. By sending that email, you create that record. You create that evidence. So important when you want to deal with workplace harassment.
Reaching out, 1-855-821-5900, employmentlawyer.ca, or this one is huge as well, pocketemploymentlawyer.ca. Tell me about it.
So we're on TV here on the weekends. We're on the radio as well a number of times. But I wanted someone to have access to this information, to answers to their questions all the time, 24/7. So I created pocketemploymentlawyer.ca. It's like having your own employment lawyer with you on your phone, tablet, desktop, what have you. So you already have an employment lawyer. It's pocketemploymentlawyer.ca. One of the things it does, it calculates the amount of severance that you're owed. First place you go to, if you have that severance letter, is pocketemploymentlawyer.ca to determine how much you're owed. Spoiler alert, you're probably owed a lot more. But beyond that, it can determine whether the company had cause to let you go. If you're an employee or an independent contractor, if you've been constructively dismissed, if there's a human rights violation, and more. So it's a way to get your answers online, quickly, anonymously, free, easy. pocketemploymentlawyer.ca.
Always get to an example, and Amy writes in and says, I was fired unexpectedly by the VP this morning. She told me that the results of my team's last project were underwhelming. I was given 7 weeks pay and severance. I worked as a manager for 7 years. Should I try to ask for my job back or just take the severance package and move on?
So let's start with the idea that maybe Amy's team's performance was underwhelming. Maybe they didn't hit their targets. That does not mean she could be let go for cause. As we said before, she can be let go, but they have to pay her full entitlement. So the question is here, what is she owed? Unfortunately, there's no mechanism, legal mechanism, to get her job back. The company cannot be made, in most cases, to take someone back to work. But it absolutely could be made to pay someone proper severance. So Amy was given 7 weeks pay after 7 years, and I bet you many people on the street, if we asked them, is that appropriate? They'd say,
week per year.
Yeah, a week per year,
Yep.
7 years, 7 weeks, that makes sense. Well, it's wrong. It's not even close. So we talked about pocketemploymentlawyer.ca. Let's take Amy's information. Let's plug that into pocketemploymentlawyer.ca, and let's find out how much Amy really is owed. So Amy is a manager. We see on the screen, she's been there for 7 years. Let's pick an age. Let's say she's 46 years old.
Sure.
She was offered 7 weeks pay. Pocketemploymentlawyer.ca correctly assesses her as being owed somewhere between 8 to 9 months pay. 8 to 9 months pay. Depending on her compensation, that could easily be $30,000, $40,000, even $50,000 difference. So
Wow.
from 7 weeks to 8 or 9 months pay, that's several times more. And we didn't pick this example, John, because it's unique. We picked it because it's not unique. It's common. Most people that come to me after they lost their job or after they went to pocketemploymentlawyer.ca find out that they're owed so much more, several times often what they've been offered. So check it out for yourself, pocketemploymentlawyer.ca.
All right, we'll take a short break here. What you need to know about overtime pay, that is coming up, so stick around. In the meantime, 1-855-821-5900 to reach out, help@employmentlawyer.ca, or shorten that simply to employmentlawyer.ca for a website where you can find past shows and our radio show as well. Lots more Employment Law Show is on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Employment Law Show. John Scholes, Lior Samfiru. What you need to know about overtime pay. We've got about 5 or 6 points, and we're going to get through these. You're going to answer them, Lior, and open up your mind about, a topic of employment law that people just don't know a lot about, right?
That's right. And on paper, it should be simple, but over the many years that I've been practicing employment law, I've had a lot of overtime issues come up. A lot of people not getting paid the overtime that they're owed, the employers not understanding when and how they have to pay overtime. So we want to demystify that issue and tell employees and employers what they need to know when it comes to overtime.
Easy question off the top. Who qualifies for it, for overtime?
So in this province, John, employees get overtime if they work more than 44 hours a week. So there's a lot of misconceptions. Some people believe, well, if I work more than 40 hours a week or if I work more than 8 hours a day. Generally, overtime is calculated weekly. So in terms of the company's legal obligation, a company has to pay you overtime if you work more than 44 hours a week. And for hours over 44 hours a week, the company has to pay you time and a half.
Gotcha.
The key here to remember is in terms of who qualifies, anyone essentially qualifies. There's some exceptions, but hourly and salaried employees qualify for overtime pay. If you work on an hourly or a salaried employee, you still get overtime, time and a half if you work more than 44 hours a week. The main exceptions are managers. So managers generally are exempt from overtime, and there's probably a lot of people watching us right now kind of saying, oh gosh, that's not very nice.
Yeah.
But overtime is generally not paid to managers. There's some other exceptions, usually professionals, lawyers, doctors, accountants, etc. But most everyone else, you work more than 44 hours a week, hourly or salary. If you work more than 44, time and a half has to be paid after 44 hours.
If you're an hourly employee, I guess the math is pretty simple, but someone's sitting back going, watching the show going, okay, I'm a salaried employee. How do I figure out my overtime?
Just as easy. Grab your calculator. So if you look at whatever you earn in a week, your weekly salary, you divide that by 44, that gets you an hourly rate. So 1.5 times that, that's your overtime rate, which means that's what you get for anything over 44 hours a week. Works just the same, takes seconds to qualify. So yes, hourly and salaried employees still get overtime.
Can your employer make you work overtime if they need you to?
So generally speaking, the answer is no. An employer cannot make you overtime if it's not your regular hours of work. So if your regular hours of work is 9 to 5, Monday to Friday, your employer cannot make you work overtime. There's a couple of exceptions to that. Number one is if your employment agreement says that your hours are 9 to 5, but we may be able to require you to work more, in which case, yes, the company can require you to work more, but of course, they have to still pay you the overtime. That's number one. And number two, in a situation where the company, there's a history of the company asking you and you agreeing to work overtime, if that history has been established, the company can continue to ask you and make you work that overtime. If you don't want to work overtime, if you're strict on your hours of work, make sure that your employment agreement doesn't allow the company to change your job or to change your hours, and make sure you don't allow the company to require, if the company does that in the past, they give you the right to do it again.
Let's flip it around. What if you need to work the overtime, but your employer is saying, no, you're not allowed to. I don't want you to.
So here's the thing. This is something that happens very often. You can get paid for overtime even if the company says don't work that overtime, as long as it's legitimate. As long as you have to do it to get the work done, the company has to pay you for overtime, even if they didn't approve it, and even in a situation where they said don't do it. Now, the fact that you may have worked overtime when they told you not to could be a disciplinary issue. They may say, well, we'll have to now give you a warning or discipline you. But you still have to get paid. The company still has to pay you for overtime. As long as it's legitimate, as long as it was required to do the job. If you say, well, the company said not to work overtime, but I have to because I got to finish this project. So you work more than 44 hours, you work your 50 hours, the company still has to pay you for that 6 hours, a time and a half, even if they've said no. They cannot refuse to pay you. A company cannot say to you, we didn't want you to work overtime, so we're not going to pay for it. That is illegal. That's a breach of the Employment Standards Act.
What if you work your week or 2 weeks, you got your 6 hours, 12 hours extra overtime, and it's not in my paycheck? What happened? What do we do?
Well, the first thing you do is you follow up with the company. Try to resolve it with the company and say, well, company, I kept track of my hours. I've worked 7 overtime hours, whatever it is, so I want to get paid time and a half. In many cases, that may resolve it. The company will pay you and you move on. If the company refuses to pay you, well, there's a number of things then that you can do. One thing, you can file a complaint with the Ministry of Labor. The Ministry of Labor can help you enforce your overtime entitlements. Remember, they can't help you when it comes to losing your job, but they absolutely can help you when it comes to your overtime. So that's option one. Another option is the failure to pay you what's owed may be something you can treat as a constructive dismissal. In other words, if the company doesn't pay you but it owes you, you may be able to treat your employment as being terminated and say, well, if you're not going to pay me, I'm going to leave, but I'm going to treat this as a termination and make you pay me my full severance. If you're willing to walk away from your job because you're not getting paid, if you want to get your full termination entitlements, for that you have to contact me and I'll help you do it. But you have options. The company has to pay you the overtime that it owes you. Can't avoid that. And if the company doesn't pay it to you, number one, you can enforce the payment, but it can also be a constructive dismissal.
Look, if you want to reach out past the 30 minutes that we're on the show to learn more, very simple, 1-855-821-5900, help@employmentlawyer.ca. And if you go to employmentlawyer.ca, you will find past shows of this nature and our radio show as well. Phone call number 2 from our radio show weekly. We're going to play it right now.
I'm a consultant, and I was retained by a technical startup company to turn it around 3 years ago. I was on a part-time basis to begin with. 2.5 years ago, they asked me to come on full-time, and that's the way it's been since then. But there's been a significant layoff, including me. They gave me 2 weeks.
Are they withholding taxes off your pay?
No.
So the question here is often happens in these situations is this person an employee or an independent contractor? Right. This happens all the time. Misclassification. A company treats someone on paper as an independent contractor. They don't withhold taxes. Person deals with their own taxes. On paper, they're considered an independent contractor. But the question then becomes, well, what does the law say about that? Well, the law's smarter than that. So if you look like an employee and you act like an employee, you are an employee. It doesn't matter what your contract says. It doesn't matter who pays your taxes. It doesn't matter if you've incorporated and have your own company, numbered company. The law still considers you to be an employee. Generally, if you have a regular job, you go to the job, you do the job, you come back home, the next day you go back and do the same thing, you are an employee. Nothing else matters. Think about it, John. If it was as simple as to create an independent contractor by simply saying you're an independent contractor, everyone could be one. And then we'd have no employment laws. So this person, let's find out if they're an employee or an independent contractor. So rather than me tell you, yeah, he's really an employee, but let's go to pocketemploymentlawyer.ca. One of the tools that it's available there is for you to determine yourself if you are an employee or an independent contractor. So let's answer the questions there under the independent contractor heading. Does he work exclusively for a company? Yes, he does. Does he set his own hours? The company sets his hours. Does he pay the expenses associated with his job? No, he doesn't. The company pays for that. And is he working for the same company for more than 6 months? Yes. So the answer you can see right at the bottom of Pocket Employment Lawyer this appears to be a classic misclassification situation. It's very likely that you're an employee, not an independent contractor. It's as simple as that. So yes, he's been misclassified, very common, and you can find out yourself about your rights, about your situation at pocketemploymentlawyer.ca.
And this can run into some serious problems. I remember, a couple of weeks ago on the radio show, we had a guy calling us, 25 years as a contractor, about 63 years old. I mean, imagine the severance this guy is owed, and the company just blew him off.
As soon as I hear 25 years, I don't need to hear anything else. He is an employee. You don't work somewhere for 25 years. Frankly, even if it was 25 months, but 25 years without being an employee, you'll never be an independent contractor for 25 years. It's silly. And yes, severance for him would be 24 months. It's significant entitlements. And you may have only worked somewhere for 6 months. You could still be an employee in the eyes of the law and be entitled to significant compensation.
All right, coming up here, what to do with working notice. In the meantime, reach out. First, pocketemploymentlawyer.ca is a good way to do so. Help at employmentlawyer.ca. And the phone number always works, 1-855-821-5900. Employment Law Show, coming right back.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employmentlawyer.ca is the website where you can catch lots more information about what we talk about here each week, plus past TV shows and our long-running radio show. A link for those as well. You can listen back in the podcast as well. From the radio show, phone call number 3, and we'll talk about it right now.
Yeah, I'm working at this company for over 40 years, and my boss just gave me a termination letter, said give me 1 year notice.
You were let go 12 months from now. You're still working.
Yes. Should I sign that letter that he gave to me?
First of all, 40 years, nicely done.
40 years,
nicely
well done. Not too many people can say they've worked for the same company for 40 years. Kudos, absolutely. But now, unfortunately, his job's going to come to an end. Then every good thing has to come to an end. And the question is, after 40 years, what is he owed? So let's start by saying that the company is allowed, instead of paying severance, the company can give you the equivalent by way of advance notice. So if someone is owed 12-month severance, as an example, the company, instead of paying that 12-month severance, can give them 12 months advance notice of termination. They can say, we are letting you go in 12 months. And as long as that notice is enough, they don't have to pay any additional severance in most cases. So for him, he got, in fact, 12 months notice, advance notice. He's still working after 40 years. So the real question, is that enough for him? You're shaking your head. You know the answer. Hopefully our regular viewers know that it's not even close. It's double that. But rather than me just tell you that, let's see how easy it is to get the answer in pocketemploymentlawyer.ca. So let's plug that information. Let's go through the very quick exercise. So let's say he's in a manual labor type of a job. We know he's been there for 40 years, assuming he's 62 years old. He was given 12 months notice or severance, the same thing. Well, he's owed as much as 24 months pay, as much as double that. You can see that right on the screen there. So what does this mean? Even though he's still working, at the end of that 12 months, the company still owes him about another 12 months pay. So the fact that you may have gotten advance notice of termination doesn't mean you're not owed more compensation at the end of that notice. In many cases, you're owed significantly more. For him, that could be another year's pay. So that's why it's so important to know your rights, to go to pocketemploymentlawyer.ca in every situation. I don't care if you're a 2-month employee or a 20-year, 40-year employee. You have to know your rights. Even a 2-month employee can have significant entitlements if you lost your job. Without any exception, you call me, you email me, even faster, 24/7, you go to pocketemploymentlawyer.ca.
We've often talked about and learned that generally 24 months is the upper threshold of what you're getting, which is a lot. 24 months is a lot. But is there times, whether it be with fiduciary CEOs or this guy who's been 40 years on the job, is there ever enhanced severance beyond 24 months, or it doesn't happen?
It is rare, and our courts have gone back and forth over the years and saying, yes, there should be more than 24 months, no, there shouldn't. Generally speaking, in a situation where you have worked for the company for a long time, and it's going to be very difficult to find a similar position, you could go beyond 24 months, as much as 30 months pay. Those are the exception, not the rule. For most people, the upper limit is 24 months. But yeah, in some situations, more senior individuals, in a small, narrow, specialized industry, you could get up to 30 months.
Another resource for you to ask questions anytime, terminationquestions.com. Again, terminationquestions.com. You can ask him there. Lior or his team will get to them and answer them in depth. We'll get to one from Singh. He says, I was a senior manager, at a telecommunications company before being let go. This was 2 years after being recruited from another company. Should my 15 years at the previous company be factored into my severance package? This guy's watched the show before.
He's watched the show, and it's reason 1,422 why it's so important to get legal advice if you lost your job. So one may say he's worked there for 2 years, he's let go. Well, he's owed severance as a 2-year employee. Well, not so fast. If he has had a job, in this case for 15 years, a long time, and he's recruited from that job, he's not shopping his resume around, he's being recruited, he's being headhunted away. We call that inducement, that's right. And then he's let go. Then the company that let him go has to recognize his service with the previous company. So now, all of a sudden, he's a 17-year employee, not a 2-year employee. So that could mean the difference between 3 months severance and maybe 18 months severance. So if you have a job, you're recruited away from that job, new company comes, hires you, recruits you away, and then they let you go, and let's say in the first couple of years, you may be owed enhanced severance that accounts for your time with the previous company. It can make a massive difference, a huge difference. We call that inducement. It only happens in a situation where you're recruited. If you've actively searched the new job, if you were trying to get hired there, then it wouldn't apply. But if you, through a headhunter or directly by the company, are recruited from a secure job, you may be owed enhanced severance.
Can that new company contract him out of that when they hire him, saying we're not going to recognize previous service? Is that legal?
Absolutely, they can. That's why it's so important to be careful with employment agreements. The company can have an agreement that says, just so you know, we're not recognizing any past service, full stop. In that situation, he doesn't get an enhanced severance. So if you're starting a job, whether you're recruited or not recruited, it's so important to make sure you understand what you're signing. It's easy to give up your legal rights without even knowing that you're doing that. Employment agreements are important documents. We'll talk about it again on a future show. But for now, if you have an employment agreement, you're not sure what it means, be concerned. Be better off to start working on a handshake. Happy to review your agreement and tell you what it all means.
Send it over anytime. More information anytime now that we are done for this show. Help at employmentlawyer.ca, simply employmentlawyer.ca to find past TV shows and radio shows. Phone number as well, 1-855-821-5900 anytime. And always, always, always go to pocketemploymentlawyer.ca. We'll see you next time right here, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.